Hearing in the appeal, Chief Fire Officer and another, and Felix-Phillip and others.
Yes.
Morning.
Good morning.
My lords and my ladies. I appear for the Appellants, together with my learned friends, Mr. Robert Strang and Mr. Kingsley Waisby of the Trinidad and Tobago Bar, instructed by Sheridan's. My learned friend, Mr. Peter Knox, Queen's Counsel, appears for the Respondents, instructed by Charles Russell and Speechlys. My lords and ladies, at the heart of this appeal are two issues concerning the interpretation of the Public Service Commission regulations as they apply to appointments to the Fire Service of Trinidad and Tobago. I would begin by summarizing the appellant submissions on each of these issues.
Yes.
And then I will go into the submissions.
Yeah.
The first issue is, what is the effect of an acting appointment to the next more senior office in the fire service until further notice, have regard to the statutory scheme which is applicable? In respect of that issue, the summary of our submissions is as follows. The effect of the statutory scheme is that the Chief Fire Officer cannot make temporary appointments for an indefinite period terminable by notice. The relevant regulations provide that a temporary appointment, which includes an acting appointment, may only lawfully be brought to an end if made for a specified period. Acting appointments made until further notice are not made for a specified period. So when the Chief Fire Officer made acting appointments until further notice, those appointments could not lawfully be determined by simply sending a notice. Therefore, they are to be treated as permanent appointments. That is to say, promotions. We submit that is what in substance they were. Appointments made for an indefinite period are treated in law as permanent appointments. That is the approach taken by the Board and the Court of Appeal in previous analogous cases. The second issue...
Why are they called acting appointments?
They are called acting appointments because the Chief Fire Officer decided to call it acting appointments until further notice, thinking that there would be temporary appointments.
Well, in effect, your argument is that an acting appointment is a permanent appointment.
Yes, ma'am. Yes.
Yeah. So what's the point in calling them acting appointments if they're going to be permanent?
Well, where the appointing authority thinks that they are temporary appointments, but in effect, the legal effect of the appointment, according to the scheme, is a permanent appointment, the court can determine whether the appointing authority is correct in calling it acting appointments when in substance it is a permanent appointment.
You mean the Chief Fire Officer did not intend them to be permanent, no, but that is their effect?
That is their legal effect.
Very well.
Yeah.
Without a probationary period?
Sorry, madam.
Without a probationary period?
Yes, madam. Yes, my lady.
But did he have any power to do that? I mean, the effect of what you're saying is he did something he didn't have power to do, and so you had no appointment at all, isn't it?
Well, he had the power to make permanent appointments for an indefinite period. So the fact that he made an appointment which is in substance in law a permanent appointment, it does not matter whether he called it an acting appointment, because the court determines whether the effect of it is a permanent appointment. And that is what happened in the Tudor case in the Court of Appeal of Trinidad and Tobago, which was adopted in the Jagru case in the Privy Council.
Okay.
Yes?
The second issue does not necessarily arise if the board agrees with us on the first issue.
Right.
The second issue is what is the effect of acting appointments when made in accordance with the criteria for permanent promotion? In respect of that issue, the summary of our arguments is as follows. Unlike in other public services in Trinidad and Tobago, when fire officers are chosen to act in a higher office, the general rule set by Regulations 154 sub Rule 1 is that they are chosen by the criteria for making permanent promotions. Where exceptionally officers are not chosen for acting appointments in accordance with that general rule, the regulations provide that such officers are not to be preferred over other officers when promotions are made. The plain intent of the regulations in our submissions is that officers chosen in accordance with the general rule will be preferred over other officers when promotions come to be made because they have already been chosen by the promotion criteria in Regulation 158.
So their performance after appointment, acting appointments, their performance is to be left out of account. Is that right?
No, my lord. Their performance can still be considered, but under the regulation, we are saying that having regard to the regulations, they ought to have preference for consideration for the promotion.
I see.
In the present case, the Chief Fire Officer, having made acting appointments in accordance with the criteria for promotion, then changed the way the criteria would be assessed for future promotions by introducing a point system. But he failed to consider the effect this would have on the appellants who had already been chosen for acting appointments under the previous system based on the promotion criteria. And he failed to account at all in the point system for the fact that they had already been chosen to act in accordance with the promotion criteria and could for that reason expect to be preferred for promotion. In applying the point system to pass them over in favor of officers who had not been chosen for acting appointments, we submit that he acted unlawfully, irrationally, and in breach of their legitimate expectations. So those are the summary of our submissions on the two issues. I will now go into the first issue.
Yeah, thank you very much.
Much obliged, my lord. The effect, and the first issue, the effect of an acting appointment to the next more senior office in the fire service made until further notice. If I can just point out to the board, the appellants were all appointed to act by orders issued by the Chief Fire Officer. And those orders are in Volume 2, 605 and 607. It may be helpful to just go to that a bit. 605 and 607.
Yes.
You would see at 605, you would see that acting appointments, fire sub-officers, and you see a column where they were promoted to fire substation officer acting appointments from the date UFN until further notice, and then you see the next column, not applicable. And in all the notices, that is the same kind of tabulation. So where we are talking in this case of Volume 2, 605, 207, and Volume 2, 618, 620, that is how the appellants were appointed to the next senior office until further notice. So having shown...
Are we putting this away? I wonder whether we should.
Yes.
Should we not read the text above the list of those who were getting the acting appointments?
Yes.
Acting appointments to the rank of fire substation officer
Are
are
made
made with effect from
yeah.
the dates shown.
It must
It
be...
must be noted that these acting appointments are not as a prelude to promotion to the substantive rank. And I think, Mr. Maharaj, you're saying that actually the effect was that they were promoted
Yes,
to the substantive
Yes.
rank.
My Lord, we have dealt that with our case, and I intended to deal with it in my submission, but I can deal with it now.
Yes.
If it is that an acting appointment to the next senior office in the fire service is not a temporary appointment, is an appointment for an indefinite period, it does not matter what is stated on this notice, because the legal effect of the regulations and the statutory scheme is that the appointment is a permanent appointment. And you would see when we come to the case of Tudor and the Privy Council decision in Jagru, that the court looks at what was done at the time of the appointment. In other words, the court considers what is the effect of the appointment in the light of the statutory scheme at the time the appointment was made. So even if the chief fire officer puts on the notice that this is not a prelude to promotion, that cannot take away the legal effect of the appointment.
But it does knock any case on legitimate expectation. You can't claim to have a legitimate expectation of something which was made quite clear you weren't going to have.
I am not claiming for legitimate expectation in respect of my first issue.
I see, okay.
It only comes in respect of the second issue.
Right.
And in respect of the first issue is a straight question of law.
Yeah, I see.
When the board looks at this appointment, until further notice, looks at the regulation, Regulation 2, Regulation 50, looks at the learning in interpreting the regulations, can it be said that an appointment until further notice is an appointment for a specified period?
Well, we're going to come to the...
Yes, we're going to come to that.
Thank you.
Well, let's come to it now, shall we?
Yes, it will. In order to come to it, my Lord, can I take you to Regulation 2?
Yes.
Regulation 2 is in tab 2, Electronic Bundle 1403. Tab 2, 1403. Your lordships and ladies would see that when you look at Regulation 2, it defines what an acting appointment is. That's 1403. Acting appointment means the temporary appointment of an officer to a higher office, or otherwise whether the office is vacant or not. And it has what appointment means. And then if you go to the next page, you will see that officer will include the fire service. Officer includes the fire service on the third line. And then we see a few definitions down. Promotion, it says what a promotion is. Then it talks at 2A. Regulations contained in Chapter 3 and Chapter 6, inclusive of the Public Service Commission regulations, other than Regulations 60, 50, etc., shall cease to apply in respect of the officer in the fire service. The importance of this 2A is that Regulation 50, which is going to be very important in this case, continue to apply to the fire service.
Yes.
So having...
Could you just pause there a moment? So from the point when the regulations of 1998 come in for the fire service, the definitions section is actually Regulation 2, not the one we've just been looking at.
Regulation
No, Regulation 2 of the Fire Service regulations.
But it says in 2A that this regulation will continue to have effect.
But not Regulation 2 of it.
It's chapter, we are in chapter 1.
Oh, I see. So this continues.
Yeah, this
And
continues.
how, which really gives rise to my bigger question, which is how do these regulations, the Public Service Commission regulations, fit with the Fire Service regulations,
Well, in
where
respect-
they've got the same provision in both?
Yes, in respect of the acting appointment, I think it's substantially the same.
Yes,
in
but
the
I
fire.
want to know really as a matter of law how they connect. We've got the same provision in this Regulation 2 and in Regulation 2 of the Fire Service regulations. How do they fit together? Acting appointment is in both of them.
I would respectfully submit that Regulation 50 would apply since it's a regulation made under the Constitution of Trinidad and Tobago. And this regulation is saying that those other regulations cease to have effect. And one can look at the regulations and see where they're in conformity or ad idem with what is in the fire service regulations.
Yes.
I intend to show the board that the decision of the courts in Trinidad that the Regulation 50 apply.
Yes, it was a more general question,
Yeah,
really, that
yeah,
it
that's
just sparked off.
Then, if I can take you to Regulation 50, which is at 1406 of the electronic bundle, you would see that at Regulation 50, the services of an officer may be terminated only for reasons stated hereafter, and then it applies to the permanent appointment in A. And then at B, it applies to the temporary appointment. And we'll come back later to B1 on the expiry or other termination of an appointment for a specified period. So what this shows is that when it comes, having regard to the effect of these provisions, when read with the definitions, is that Regulation 50B applies to acting appointments and sets the only ways in which they may be lawfully terminated. Because in Regulation 2, it says acting appointment includes temporary appointment. So what we are seeing, our submission is that Regulation 50B applies to acting appointments and set the only ways in which they may lawfully be terminated. And the board would see that on the expiry or other termination of an appointment for a specified period.
Very interesting, isn't it? The phrase
Very interesting.
expiry or other termination.
Yes.
Expiry, obviously talking about a fixed term, but they don't leave it at expiry. They go on to say or other termination, and we will have to come back to that.
Of an appointment for a specified period.
Indeed,
Yes.
indeed.
Yes.
Very well.
Much obliged, my lord. That proposition, that is that Regulation 50B applies to acting appointments and sets the only ways in which they may be lawfully terminated, was accepted by the Court of Appeal at paragraph 48 of the Court of Appeal judgment. So if I can show you Volume 1, page 497.
Sorry, which page, please?
Volume 1, page 497.
497.
At paragraph 48, it says, further in considering Regulation 2, one must also consider Regulation 50B1. Regulation 50B1 provides that the services of an officer holding a temporary appointment, defined by Regulation 2 to be an acting appointment, may be terminated on the expiry or other termination of an appointment for a specified period. The regulation contemplates that ordinarily the period of the appointment will be specifically fixed by dates. The question is whether an acting appointment, which is not fixed by dates, but which is made until further notice, is for a specified period. In my judgment, I'll come to this later, but I want to read it at this stage.
Sure.
In my judgment, specified period does not necessarily require that the period be fixed or closed by dates, provided that by the terms of the appointment it is clear that the appointment is temporary. In this case, the term until further notice, coupled with the fact that it is an acting appointment, conveys that it is a temporary appointment which would be terminated upon the giving of formal notice. The giving of such notice concludes the period. I will show later that that is wrong reasoning, because, but if you permit me to just go forward a bit before I go to that.
Yes, go on.
Yes. And this was also the finding of the High Court, Justice Barrow, as he then was, in the case of Melville and Lala, and that is at tab 10 of the bundle of authorities. Just find tab 10 here for me. Yeah.
This point argued below.
Sorry, ma'am.
Was this point argued below?
It was argued in the High Court, and our contention is that it was argued by a side win in the Court of Appeal. And if you permit me, I could deal with that later.
We'll explain.
Yeah, yeah. If I take you to page 1572, you see that at the paragraph after the Regulation 50 was referred to, the consequence of the definition in Regulation 2 is that an acting appointment is governed by Regulation 50B. The mandatory language of Regulation 50 requires compliance, and anyone holding a temporary appointment, including an acting appointment, can be terminated only in accordance with Regulation 50B. The respondent now argues that the Court of Appeal were wrong and that the decision in Melville was wrong. In my written case, I submitted that the respondent should not be allowed to take this point. But I am not going to seek to prevent the respondent from running his argument. I do observe that before the Court of Appeal, the respondent did not take on the argument that Melville was wrongly decided. And he did not argue that Regulation 50 did not apply at all to acting appointments. He argued that it should be read as applying to some acting appointments but not others. That can be seen at Volume 1, page 415 to 417, from line 46. And if you forgive me, I would not, it's a transcript, but I would not go through it with the board unless you want me to go through it.
No, I don't think that's necessary.
Could you give the reference again, though, please?
Yes, Volume 1, page 415 to page 417, from line 46 on page 415 to line 21 on 417.
Thank you.
The respondents are now submitting that Regulation 50 does not apply to acting appointments because it is only intended to deal with the termination of an officer's services, that is to say, according to the respondent, the complete termination of the officer's service in the public service. That can be found at paragraph 20 of the respondent's case.
Yes.
That argument was, however, dealt with in Melville by Justice Barrow, as he then was, at page 1572 of Melville.
We've just been looking at that, haven't we?
No, we looked at the paragraph before. We looked at the paragraph before which says the consequence.
Okay.
Yes, I'm referring to the next paragraph. The interpretation placed on Regulation 50 by the Commission and articulated by Mr. Walker. Mr. Walker was the lawyer on behalf of the public authority, appears to have been guided by the phrase, "The services of an officer shall be terminated." Having regard to Regulation 2, there is no basis for construing termination of the services of an officer to mean only such termination as results in the complete separation of the officer from the civil service. Rather, in the case of an acting appointment, it includes termination of the services of an officer where those services are being performed in a post higher than that to which he or she is substantively appointed. So it is clear that Justice Barrow, as he then was saying that these principles in construing whether an acting appointment is a permanent appointment or a permanent promotion is not limited to where there's an appointment to the service. The principles also apply where there's an appointment and promotion within the service. The respondent is also saying that officers do not hold acting appointments because they do not hold office. They merely act in it. That's what the respondents are saying. That can be also seen at paragraph 20 of the respondent's case. We submit that argument is wrong because it pretends that there can be no distinction between holding office and holding an appointment.
Mr. Maharaj, you're taking some prima facie quite good shots at the new point that's being raised. But the burden of your submissions will have to be to persuade us that what the Court of Appeal said, not what Mr. Knox now aspires to say, is wrong.
I take that, my lord.
Very well.
I just want to spend a few minutes, if you permit me, because I'm going to that, my lord.
Okay.
I just want to put it in a context, if you permit me, just for a minute or two.
Of course.
Much an officer who has an acting appointment can be said to hold an acting appointment. Indeed, that is how it is said in the statutory scheme. And I just want to refer the board to the statutory scheme and point out the regulation, that it expressly refers to it in that way. For example, if you look at the fire service regulations governing the terms and conditions of employment, and that is at tab 5, the page number is 1440, 1440, regulation 30 is at 1462, and sub-regulation 8 over the page, it talks about holding an acting appointment, and look at sub-regulation 9 also. So that is the statutory language, holding an acting appointment. And then you will see it also in regulation 35.5 at page 1466.
So sorry, which was the second reference? I've got 30, subsection 5.
I'm sorry, my lady.
You gave us two references.
I gave you tab 5, page number 1440. That's regulation 30 at page 1462.
Yes.
That's regulation, sub-regulation 8 and 9. And then another example is Regulation 35.5, Sub-Rule 5 at page 1466. And if I could go straight into what my Lord Wilson wanted me to do, my Lord.
Thank you.
My final point on the application of Regulation 50 is that if the respondent is right, then there are no regulations governing the termination of acting appointments. The regulations, however, make detailed provisions for the making of acting appointments and for the treatment of potential appointees for acting appointments, because they have to make representations, they give right to make representation, etc. And they make detailed provision for the termination of temporary appointments. I respectfully submit that it is most unlikely that in that context that it was intended that there be no provision for determination of acting appointments. So for those reasons, we submit that Regulation 50 applies to acting appointments. And we make this submission in particular about Regulation 50. Regulation 50 does not permit the Chief Fire Officer to make acting appointments for an indefinite period terminable by him at any time by notice. That is the gravamen of our submission with respect to Regulation 50. Now, I show the board Regulation 50B1, and because I can just take you back to it, Regulation 50.
And what you're saying is that the mere fact that you're saying here it's terminable by notice doesn't affect the principle that you've said, because that would be an easy way of evading the legislation.
Yes, madam. And if it is a permanent appointment, it has to be terminated for cause. And there's a process for that. There's a procedure for that.
That's the second issue.
Yes. I show the board Regulation 50B1, which can I just look at it? If you recall, 50B1 says, it's at page 1407 in the electoral bundle, where the officer holds a temporary appointment on the expiry or other termination of an appointment for a specified period. The effect of that provision, we submit, is that to bring a temporary appointment to an end, it must be an appointment for a specified period. An acting appointment made until further notice is not an appointment for a specified period. It is made for an indefinite and indeterminate period.
Could I ask you about paragraph 48 of your case, if that's convenient?
My lord.
You're explaining to us what 50B requires.
Yes, ma'am.
If you've got 48, that means that the period is to be specified either by describing the length of the term for which the appointment is to run, or specifying the date on which it's to end, or by specifying some event, say the return of an office holder from study leave, that will bring the acting appointment to an end.
Yes, ma'am.
And I've been focusing upon your reference to an appointment until the office holder returns from study leave.
Yes, ma'am.
Now, that is not a fixed period. We don't know when he will return from study leave. And I was wondering what the difference was between an acting appointment whenever he returns from study leave, on the one hand, and an acting appointment until we give you notice of termination on the other.
Well, at least at the outset, if it's upon the return of the officer from study leave, it will be known by the officer that upon his return, it means that it's for a specified period. But until further notice is at any time that the appointing authority considers that it can be terminated.
Quite.
And that has to be indeterminate.
So the acting officer knows that at any time he may receive notice, and that will be the end of his acting appointment.
The appointing authority knows that he can give a notice, thinks that he can give a notice at any time.
I agree.
And that will be the end.
Indeed.
And the officer, the officer would not know whether this appointment could last for 5 years, 6 years, 10 years, or 15 years.
And he doesn't know when the office holder will return from study leave.
Yes. And when we go through how the Court of Appeal looked at Tudor and how the board looked at Tudor with the regulations, it is important for the officer and for the court to know at the time the appointment was made whether the appointment is for a specified period or not. I concede that if the appointment is made for an officer returning on leave, the return of the officer defines the event which terminates that particular period of appointment.
What if that is an indefinite period? The officer may study for a year, he may study for 2 years. Does it matter?
Well, I think normally it will be known by the public service, the time of the study leave.
Well, it would normally be known, but not necessarily and inevitably be known. And what if the public service said to the acting officer, you're appointed as an acting appointment, but we are at liberty to bring it to an end with due notice? Would that satisfy the regulation?
Well, no, because you'll have to say a specified period. You have to define it. Specified period in law at the outset has to be defined by when it will come to an end.
The only way in which you can bring it to an end is if at the very beginning you specify precisely which period you're going to be acting up.
Or some event which would bring it to an end.
Well, could the event not be the giving of notice by the authority?
The problem with until further notice is, in effect, a termination at pleasure of the appointing authority. And when we come to look at the case of Endell Thomas, since these are regulations made under the Constitution.
Well, let's have a look at that now, shall we?
Just before we move to it, does the same principle apply to somebody who's acting during a sick leave period?
Well, if the appointment is until someone returns from sick leave, and it is specified that from sick leave, because normally when an officer gets leave, a period is specified.
Yes, so the reason I'm taking sick leave is because your answer before was that you would know when somebody was coming back from study leave, but you wouldn't on a sick leave.
Yes.
So I'm asking you which side of the line that falls.
You will know that it's an
okay.
event. Yes.
It's okay, it's a specified period.
Yes, it's a specified period.
Well, now let's go to the case that you were going to refer us to.
Yes, Endell Thomas is at Endell Thomas is where it's at,
Tab 7.
tab 7. Is it tab 7? Endell Thomas is at tab 7, my lords.
Yes?
That is a case, tab 7. What page it is? That's 7
It's
1498.
1498.
1498.
To 1511.
Yeah, and if I can take you to 1511.
This is by
If I can take you to 15. 1511, starting with the paragraph, the way the argument for the Attorney General, starting there at the last paragraph or the second to last paragraph.
Yes, thank you.
The way the argument for the Attorney General was put before the board was that in the case of police officers, the exercise of the right of the Crown to dismiss its servant at pleasure was merely transferred by Section 99 of the Constitution from the Governor-General to the Police Service Commission and was embraced in the power to remove from office that became vested in them by that section. The contention was that the Commission need not look for any reasonable cause for exercising its power of dismissal in the particular case, although in practice it would normally do so. Nevertheless, it is legally entitled to act without any reasonable cause, but simply and solely at its own whim, though that, of course, is not what it's purported to do in the instant case. In their Lordship's view, there are overwhelming reasons why remove in the context of to remove and exercise disciplinary control over police officers in Section 99(1) and in the corresponding sections relating to the other public services must be understood as meaning remove for reasonable cause of which the Commission is constituted the sole judge, and not as embracing any power to remove at the Commission's whim. To construe it otherwise would frustrate the whole constitutional purpose of Chapter 8 of the Constitution, which their Lordships have described. It would also conflict with one of the human rights recognized and entrenched in Section 1D of the Constitution, the right of the individual to equality of treatment from any public authority in the exercise of any functions. Dismissal of individual members of a public service at whim is the negation of equality of treatment. In the case of Endell Thomas, what Lord Diplock and the board was considering, whether it is possible for public officers not to have security of tenure. And what the board was saying is that you could not dismiss a public officer at will, on the whim. And I think the same principle applies, that you cannot demote at whim. Because
was this a case about a police officer acting in a particular capacity above his substantive capacity?
No, this was not a case of that.
It was not.
No, this was a case. This was a case in which the question arose as to whether, having regard to the Independence Constitution, public officers are insulated from being dismissed at pleasure. And we are saying that the same principles apply, that you cannot demote them at pleasure, that you could only dismiss a public officer for cause. So what we are saying is that if this is a permanent appointment and not a temporary appointment, then obviously, and when you're looking to determine whether it is a permanent appointment or a temporary appointment, you have to bear in mind the constitutional context in which the regulations have been made.
Right. Where are we now then?
So if I may, our submission is to appoint someone until further notice, is to say your appointment ends when I say it ends. That is not an appointment made for a specified period. It follows that Regulation 50B does not permit such appointments to be terminated by notice. And we submit that the Court of Appeal, in finding that Regulation 50B did permit acting appointments until further notice, was wrong. Justice of Appeals Barrow's reasons are at Volume 1, page 497, at paragraph 48. I just want to remind, because the board will have to examine those reasons, because those are the reasons on which the Court of Appeal relied to say it was not a permanent appointment. So at paragraph 48, apart from what he said about Regulation 2 and Regulation 50B, if I can take it, is that the question is whether an acting appointment, which is not fixed by dates, but which is made until further notice, is for a specified period. In my judgment, specified period does not necessarily require that the period be fixed or closed by dates.
Well, I think we've read this already, haven't we?
Yes, I read it, but I want to go into his reasoning, my lord.
Well, I think we're familiar with it.
Much
What point do you want to make about it?
Justice, the reasoning of Justice Barrow deprives Regulation 50B1 of effect in our respectful submission. It says that a temporary appointment does not need to comply with the regulation as long as it is clear that it is temporary. That is what he's saying. His further reasons are at paragraph 50 and 51. Can I ask you to look at 50, and I'll ask the board to read 50, and I'll just read 51.
Yes.
At paragraph 51, he says, I hold that whereas in this case, an acting appointment is made until further notice, the serving of a notice which brings the appointment to an end will be such an event. This is entirely wrong, we submit. We submit, for the reasons we have already given, to appoint someone until further notice is to say your appointment ends when I say so. That is not an appointment made for a specified period. What is the effect of purported acting appointments until further notice? We submit that they must take effect as permanent appointments. That was the approach taken by the Court of Appeal in the case of Tudor and the board in the case of Jagru. Tudor is at tab 13, at page 1611.
Yes.
Tab, page 1611. You'll have to give me just have you got it, Maya?
Yes.
It's page 1611.
Yes, thank you.
That case concerned the purportedly temporary appointment of Mr. Tudor to a junior teaching post. No period of appointment was specified. Having first worked in other parts of the public service, he was appointed by the Commission by letter, which he said he had been seconded for duty as a teacher. If the board looks at page 1612, you would see at the first paragraph, that letter was referred to the 16th of March, 1977. The authorities' case was that the secondment entailed a temporary appointment. He was then transferred to a different location by letter which expressly informed him that his appointment was purely temporary. And if you look at the same page, 1612, you will see at the end of the second paragraph, that letter is referred to.
Yes.
When he challenged the subsequent termination of his appointment, the Commission claimed to be entitled to terminate for a number of reasons, one of which was it had been a temporary appointment, and that is at page 1618. Beginning at the third paragraph from the word where you have the board, that meant the appeal board, not this board. And if I may read from there, the board, that is the Public Service Appeals Board, in its judgment, gave as one of the reasons for upholding the dismissal of the respondent the fact that in the appellant's letter, Exhibit G, dated 19th June 1981, in which he set out reasons why he should not be dismissed, he neither dismissed nor challenged in any way the fact that his appointment had once been one of a temporary nature, and then went on to say that the respondent was not a teacher as stated above. What it appears the board failed to consider was what was the legal effect of the letters of the 16th of March 1977 and 17 September 1979, rather than what the respondent herein considered his appointment to be, and whether he disputed or challenged the temporary nature of his appointment. By Section 58 of the Education Act, a member of the teaching service shall hold office subject to this Act and any other written law, and unless some other period of employment is specified for an indeterminate period. Accordingly, if the Service Commission wanted to appoint the respondent temporarily, then it should have specified the period for which the appointment was being made. Not having done so, the letters of the 16th of March 1977 and the 17th of September 1979 in law constitute a contract of employment for an indeterminate period. No law correctly interpreted permits a temporary appointment other than for a specified limited period. There cannot be a temporary appointment ad infinitum, and I would so hold.
But in this case, the first letter didn't mention that it was temporary, did it?
No, and it didn't mention it was for a specified period.
No, but it's therefore different from the present situation.
Yes.
It was only in the second letter that they said that it was temporary.
Yes. So the secondment did not mention.
Do we have to read the next paragraph, Mr. Maharaj?
Sorry, ma'am?
Do we have to read the next paragraph, Mr. Maharaj?
Yes, I was coming to that, ma'am.
Since the Teaching Service Commission had seconded the respondent to the post of Technical Vocational Teacher 1, which is a permanent office in the teaching service, without stating any specified period. In law, the respondent was appointed there too for an indeterminate period. So the office had to be permanent. So he was appointed to it. So it was a permanent appointment. So what do we collect from this?
Well, in the vacant offices, those are supposed, in the fire service, those are supposed to be offices which are available for permanent appointments. So the principle is that if you are making an appointment and is not for a specified period, that is the principle with the greatest respect, my lord. If the appointing authority is making an appointment, whether it's an appointment on secondment, whether it's appointment to the service, or whether it's appointment on promotion, having regard to Regulation 50B, if you're making that appointment, you have to show by the appointment that it is for a specified period. Otherwise,
my Lord's point is a different one. He's pointing out, pertinently in my view, that this was a permanent post to which the appellant was appointed. By contrast, in the present case, there is no suggestion that the appellants were appointed to permanent positions.
so what I would say for that, my lord, that in the Court of Appeal judgment, the appointment of Mr. Tudor, even though it was to a permanent position, the Teaching Service Commission had purported to make a temporary appointment, but in substance, it was a permanent appointment, not because...
I mean, my Lord's point is that the post itself was permanent, and therefore, whatever the Teaching Commission sought to do, they were actually appointing him to a permanent post. By contrast, the appellants were not appointed to a permanent position in this case. they were told that the appointment was until further notice. And by definition, that could not be to a permanent post.
Our submission is that the posts to which the appellants were appointed to act were permanent posts.
I see. Right. Well,
The secondment purports to be temporary, just as acting appointments. It purported to be temporary.
right.
I mean, in this case, we have this clear provision in the statute, unless some other period appointment is specified, it shall be for an indeterminate period. So that basically says you look and see whether a period is specified. If it isn't, it's an indeterminate appointment. We've got nothing like that here.
Yeah. At paragraph 16, at the next paragraph on page 1619 of Tudor, if I may just read that for the board, because this may assist. Since the Teaching Service Commission seconded the respondent to the post of technical vocation tutor, which is a permanent office in the teacher service, without stating any specified period, and I emphasize that with the greatest respect.
That's because it's what the
In
statute
law, the
says.
respondent was appointed thereto for an indeterminate period, and his appointment was not of a temporary nature, but one that made him a permanent member of the teaching service.
But there's a distinction between appointing someone indefinitely and appointing them until further notice. Indefinitely, you're not proposing to necessarily move them, but if it's until further notice, you're contemplating there will be notice. Same
Well,
thing.
where the court has to construe whether the appointment is indeterminate or whether it is for a definite period, the court has to construe it in the context of the regulation.
But it's not that question here. The question is, was it for a specified period? It is not whether it was indeterminate.
Well, our submission is a specified period cannot be until further notice. An appointment until further notice is not for a specified period.
So until further notice is an entirely otiose expression.
Well, I'll put it this way, my lord. It is an expression which does not define the end of the acting appointment.
Well, it has no legal effect.
The legal effect of the appointment is that it is permanent.
Yes. Well, therefore, it follows, does it not, that until further notice has no legal effect whatever.
Well, I wouldn't say it has no legal effect, my lord.
Well, which legal effect does it have?
Until further notice has to be construed in relation to the regulations which govern appointments. And therefore, if the regulation says that a temporary appointment has to be for a specified period, then the court has to construe it with that definition in mind.
Well, does until further notice, do those words have any legal effect? And if so, what is it?
Well, the legal effect is that it is a permanent appointment, it's a promotion.
Well, it means, therefore, that it has no legal effect, doesn't it? Surely it follows.
The question of illegality, with the greatest respect, my lord, does not arise. And the reason for that is that the chief fire officer had the power, not that he did not have the power to make permanent appointments. And he cannot make an appointment which purports to be a temporary appointment and calls it a temporary appointment when in law it is a permanent appointment and raise illegality and ultra vires.
But if I can just put what I think is my Lord's point in a different way, supposing that the employer says, right, I'm going to rely on my until further notice provision here, what would you say to him? Would you say, well, you can't do anything under that. You can't serve a notice. You can't It doesn't define anything. My Lord's asking, what difference does it make?
He can say that you're not entitled to terminate my appointment because I am a permanent promotion.
So until further notice means nothing in the context of this contract.
It's permanent, and you have to terminate me for cause in accordance with the regulations.
Right.
Your answer to my Lord, Lord Kerr, is yes. Until further notice has no legal effect. Can't you face up to that, Mr. Maharaj?
Well, it has legal effect in the sense that it is. Well, in that context, it does not have legal effect.
Very well.
Right, let's move on.
I'm sorry.
That's all right. No, don't worry. Let's move on.
The reasoning of Tudor was cited with approval by the board in JAGRU. And JAGRU is at tab 9 at 1534. Have you got it, Mike?
Yes?
Yes. At paragraph 12 at 1539, the board would see that they endorse what Justice of Appeal Daisy said, no law correctly interpreted at paragraph 12 permits a temporary appointment other than for a specified limited period. There cannot be a temporary appointment ad infinitum. In JAGRU had also been appointed as a teacher by a purportedly temporary appointment. His first letters of appointment specified fixed periods of appointment, but these were in some cases issued retrospectively. And in any event, there followed a period of time in which he was not employed on a fixed term. Then he received a final letter retrospectively appointing him for a fixed term, which purported to bring his appointment to an end. He submitted in reality that he had been appointed for an indefinite period. If I can ask you, the board, to look at page 1546, paragraph 32.1. 1546, paragraph 32.1. That is where he submitted that in reality it was an indefinite appointment. Then at paragraph 36 at page 1547, the board agreed. I need it. Somebody get it for me. Paragraph 36.
Yes?
At paragraph 36, I asked the board to read it at the beginning, and then if I take it, the second to last line at the end of paragraph 36, he was not holding an appointment for a fixed term. He was therefore holding an office for an indeterminate period under section 58 of the Act, as it was not open to the Teaching Service Commission by retrospective appointment letter to deprive him of the protection of section 62 of the Act.
Can you help on the facts? The early letters that he got when he was first appointed didn't say anything about it being temporary. Is that right? It was only this later one.
Correct.
That said so.
Yes.
Like the teacher, when
Yes.
it was only the later letter that said so. Right.
So what it shows is that even if you make an appointment and the legal effect is that it is a permanent appointment, even if you write letters afterwards saying it is probationary or it's temporary, the court looks at what was the status, the legal status of the appointment when it was made. So we submit that the operative principles applying in Tudor and JAGRU apply in this case. The law does not permit a temporary appointment other than for a specific period, limited period. There cannot be a temporary appointment ad infinitum. an appointment for an indeterminate period is a permanent appointment. And the respondent has suggested that if he had no power to make in an acting appointments for an indefinite period, then these appointments were unlawful and null and void and could be terminated for that reason. We do not accept that it should be open to the respondent to achieve the ends he deserves by pleading his own illegality. In any event, we submit he is wrong. While the respondent may have had no power to make acting appointments for an indefinite period, he did have the power to make appointments for an indefinite period. That is to say, permanent appointments of promotion. We submit the proper analysis is that the chief fire officer, by making appointments until further notice, was making permanent appointments. And two, that by purporting to call them acting appointments, he could not have given himself the power to make them temporary or terminate them at will. The result is we submit that the appointments of the appellants until further notice were permanent appointments, and we ask the board to declare that the appellants be treated as having been promoted from the date of their appointments. Before moving on to the second issue,
before
however,
you do, your submission, could I just ask you a point? Your submission on paragraph 12 of the Jagaru case was that the dictum in the Tudor case had been cited with approval. But as I read the paragraph, it was merely a description of the submissions. The mere fact it was set out as part of the submissions of counsel in Jagaru would not mean it was cited with approval.
If that is the case, I do apologize, my lady, but the judgment, in effect, applied the principles decided in Tudor.
Well, I understand the judgment at paragraph 35, 36 and 37 is on what was described as the narrow ground, which is what you couldn't change status retrospectively.
Yeah.
You couldn't turn a permanent appointment into a temporary appointment retrospectively. That's not this case. It's clear from the outset.
But that is important for assessing whether the appointment is permanent or not, because you take it from the date that the appointment was made. What is the effect of the appointment?
Right, thank you.
So before moving on to the second issue, I would like to deal with the practical effect of the respondent's use of acting appointments. His position is that it is necessary to have the power to make acting appointments until further notice, to have the flexibility to deal with the needs of the service, and these acting appointments are simply an example of good administrative practice. That is at paragraph 21 of the respondent's case. We disagree with that, and the evidence contradicts it. As we have pointed out in our written case, the respondent's practice was in fact to maintain large numbers of acting appointments at all times. Thus, even after making a large number of promotions in the second division in September 2010, the list is at volume 2, page 703, he made further acting appointments as well, so that there continued to be more than 100 acting fire sub-officers and more than 100 acting fire substation officers. And that can be found at paragraph 38 of our written case, page 1329. The effect of that was, as we submit, to create a permanent second class of officers at each level who performed the same duties, but who could be demoted at any time without cause. That is at odds with the constitutional basis for the statutory scheme as expounded in the case of Endell Thomas, and I cited that to the board. And I emphasize that this situation continued indefinitely. In the cases of the appellants, they continued to act in some cases until they retired or until they were finally promoted in 2016, 8 years after first being appointed to act. I have set out the information for each appellant in Appendix 1 to our written case. The second effect, as it happened, was that acting officers did not receive their full pay for the several years. At tab 5, under the Fire Service Regulations, Regulation 30 at page 1462, Regulations 31 and 32, 30 sub-rule 1 and 30 sub-rule 2, officers appointed to act are to receive payment additional to their salary in the form of an acting allowance. In fact, the payment of the appellant's acting allowances was delayed for many years, and the judge, in her judgment at Volume 1, 231 at paragraph 58, referred to it. So in fact, as it happened, acting allowances were treated differently from salary. It would have been different if the appellants had been promoted. Their salary would have changed. The effect of this, and in the Court of Appeal, at Volume 1, pages 508 and 509 at paragraph 75 and 76, the Court of Appeal took the position that since the Attorney General was not a party to the proceedings, it could not deal with the acting allowances. I'm just mentioning this. The effect of this practice of maintaining large numbers of acting appointments was that the respondent was able permanently to increase the number of officers in the more senior roles, while nobody had budgeted for the increase in pay required. The further effect on the appellants was they lost seniority and were deprived of the opportunity to further promotions and to act in higher offices. By being promoted in 2016 instead of, say, 2008, they have missed out for 8 years on the chance of having been promoted further. And that includes missing the chance of being promoted to the first division of the fire service. Promotion to the first division is significant for fire officers because it means that they can stay in office for 5 years longer. Officers in the first division must retire at 60, the second division at 55. That can be seen in Regulation 46, page 473, of tab 5 of the bundle. I have drawn attention to these matters to the board to show the ways in which the appellants were prejudiced and to dispute the respondent's contention that his acting appointments until further notice were just an aspect of good administration. They were not. Finally, I would add that it is not impracticable to specify in advance either the period of an acting appointment or the event that will bring them to an end. That should be within the scope of any well-run administration. And the process of making acting appointments is designed to be a careful process, as I will show on my second issue.
Yes.
I move to the second issue, my lord, and the second issue is the effect of acting appointments made according to the criteria for promotion. The relevant regulation is Regulation 154. Regulation 154. And if your lordship look at 154.1.
Which page is that?
Sorry, page 1408. Subject to Regulation 157, the Chief Fire Officer shall ensure that recommendations made in relation to an acting appointment are based on the criteria prescribed in Regulation 158. And Regulation 158 gives the promotion criteria. If you look at 158, the board will see in considering officers for promotion and sub-rule 1, 2, and 3, the different promotion criteria. Then, if I can show the board Regulation 155, subject to Regulation 157, where an acting appointment forced to be made by the Commission, the Chief Fire Officer shall notify all eligible fire officers. And I will not read it out, but in summary it provides that when the Chief Fire Officer appoints officers to act in accordance with Regulation 158, he must take care to ensure that all eligible officers are included for consideration and must give all officers the opportunity to make representations. And then, if I can read, I ask the board to note 156, but if I can read 154 sub-rule 2. Where in the exigencies of the service it is not practicable to apply the principles prescribed in Regulation 158, the fire officer selected for an acting appointment shall not be given any preference over the eligible officers for a substantive appointment. So the regulation is making a distinction between officers appointed in the exigencies of the service. They do not have to satisfy the promotion criteria, and other officers who are appointed.
Well, surely it's not making a distinction. It's saying that where in the exigencies of the service it's not practical to apply the principles prescribed, the fire officer selected for an acting appointment shall not be given any preference over others who might be eligible for appointment. It's not making a distinction between the two of them. It's removing a distinction, isn't it?
And we are submitting that the converse applies. And that is why we are submitting that in this case, it is not disputed that the appointments of the appellants were made in accordance with Regulation 154.1. And we submit that the judge was right to find that officers appointed in that way will be given preference over other eligible officers when it comes to promotion. Her finding is at Volume 1, paragraph 222, at paragraph 39, at the bottom of the page.
Yes.
And if I may just read it. If an officer not appointed to act pursuant to Regulation 158.
Sorry, where are you reading from?
Volume 1,
Yes.
page 222, paragraph 39.
Thank you.
Sorry, my lord. At the bottom of the page.
Yes.
If an officer not appointed to act pursuant to Regulation 158 is not to be considered in preference to any other eligible officer for promotion, then it would seem to me that the converse is true, that an officer appointed to act pursuant to Regulation 158 shall be given preference over eligible officers for substantive appointment. We submit that the judge was right. It makes sense that the general rules is that officers chosen under Regulation 1541 should be preferred for promotion because they have already been chosen once ahead of the other eligible officers by the criteria for promotion. And it gives proper effect to the requirement in Regulation 1541. If officers appointed to act pursuant to Regulation 1541 are not to be given preference, one might ask the question, what is the point of requiring that they be chosen according to the criteria for promotion? On that basis, Regulation 154.2 expresses the alternative option as an exception to the general rule we submit. The reasoning of the Court of Appeal overruling the judge is at Volume 1, page 499, at paragraph 55. If I may read that to the board.
Yes.
Having stated in paragraph 54 what the judge found, Justice of Appeal Barrow said, I do not agree. In the normal course, persons appointed to act in an office on the basis of substantive promotional consideration would normally be expected to be appointed to the substantive post ahead of other aspirants to the office if they have been performing at or above the required standard. In that sense, it may be that they are to be preferred. What Regulation 154 seeks to prohibit is that preference be given to an officer simply on the basis of appointment to the acting position when the appointment is based on urgency and need due to the peculiar circumstances then existing in the public service. But it does not follow that an acting appointment effected by applying Regulation 1583 criteria requires that those appointees be preferred when permanent appointments are to be made in the substantive post. Express provision to that effect is required. In the absence of such express provision, a substantive appointment can only be based on Regulation 1583 criteria, in which experience in the acting appointment is taken into account but not preferred. In this case, experience was factored in and specific points allocated for it. So if I may deal with the reasoning of Justice Barrow. So Justice of Appeal Barrow accepted that officers appointed to act on the basis of their criteria for promotion would normally be expected to be promoted to the substantive post ahead of others. But its reason for saying that the regulation should not be read as requiring it was that the only express criteria for promotion were to be found in Regulation 158.3. We submit respectfully that Justice of Appeal Barrow went wrong here because he did not give proper effect to Regulation 154. He read Regulation 158 on its own instead of understanding the scheme as a whole. Regulation 158 has to be understood in conjunction with Regulation 154. The appellants we submit were unlawfully passed over for promotion. So the appellants, having been selected for acting appointments by the promotion criteria in Regulation 158, ought to have been preferred over other officers who had not been so chosen when it came to the substantive promotions. They were not. They were passed over in favor of officers who had not been chosen to act in the higher office. A list of the officers promoted ahead of them is at Appendix 2 of our written case. The reason for that is that the point system that was used to make promotion in 2010 was incapable of giving effect to the requirement that the appellants be preferred. The point system is at Volume 2, 645, and if I may just ask the board to look at that. Have your lordship found it, my lord?
Yes.
Yeah. My lord, you would see that in the point system, it had the regulation and the heading. So you see the first one was General Fitness, Regulation 158A. And then
sorry, could you just give me the page again?
645.
Thank you.
645.
Thank you.
And I'm looking at, yes, 645.
Thank you.
And so you have Regulation 158 at the top, General Fitness, and I'll just go through the headings. They have performance, the next page, Performance Appraisal, Regulation 158D. Then you have at the end of that page, Commendation, Special Report, Regulation 158E. And then you have the next page, Special Report Service. Then you have Relevant and Relative Experience, Regulation 158.1E and I. Then you have Experience Performance Duties in Vacant Office in the Fire Service, Fire Sub-Officer, and Fire Substation Officer. And that is the heading. Now, looking at the point system as each heading of the point system purports to take into account the subsection of the Regulation 158.3. So I make the following observations, my lords and my ladies.
Have we left the point system?
So,
Have we left these pages?
Yes.
Could we just look back at 647 for a moment?
Yes.
halfway down, relevant and relative experience, maximum points, experience in vacant office, 5. And then that's broken down.
Yes.
Experience performing duties in the vacant office, in the fire service, 2 years and over, the maximum. Bit less, 4. Bit less, 3. Now, correct me if I'm wrong, those points can only be collected by an acting officer. Because he's only an acting officer will have had experience in the vacant office. Am I right?
Well, my lord, our point is that it applies to vacant experience, acting officers with experience, but it makes no distinction between officers acting under 154.1 who have had the promotion criteria satisfied and officers who were appointed under the exigencies of the service.
But forgive me, your clients under the point system can get up to 5 points in circumstances where people who haven't been acting as in a capacity higher than their own can't. So you're getting preference here, are you not, Mr. Maharaj?
No, my lord. We're not getting preference because it mentions nothing about appointments under 154.1 where you satisfy the promotion criteria. And that is a submission I was about to make when your lordship asked the question. The point system takes no specific account of any acting appointments under Regulation 154.1. It awards points for time spent acting in the vacant office, but gives no significance to the fact that such appointments under Regulation 154.1 would give a preference. It makes
What do you mean by preference?
Well, we are saying that...
I mean, to my mind, this gives the acting officer some preference. If by preference you mean that he will necessarily be appointed above somebody who's not been an acting officer, then of course, on that definition of preference, this doesn't go far enough.
We're saying a preference to be considered, a preference in consideration, because have regard to this statutory scheme that I submitted, that if you satisfy the promotion criteria we are submitting, that there should be a preference in the promotion exercise. So what we are saying is that where you're awarding the point system, and it makes no distinction between acting appointments under Regulation 154.1 and 154.2. In other words, you're putting the persons who did not satisfy the promotion criteria on the same level, on the same basis as those who satisfied the promotion criteria.
Thank you.
And it took no account of when acting appointees have already been chosen once according to the Regulation 158 criteria. So those are our submissions, and that we submit that for those reasons, the point scheme was irrational because it is not reasonably apt to achieve the objectives of the statutory scheme. And we refer to the case of Ganga, which was decided by the board. That is at tab 8. It's tab 8, page 1530, and at paragraph 21, it says it is not in dispute that the system, that had to do with the point system, there's no dispute that the system had to be reasonably apt for achieving the statutory objective of taking account of the Regulation 20 criteria. So the point system, if you're going to use the point system, it has to pass the test of being reasonably apt of satisfying the statutory scheme.
And what did the board say at 25 and 26, Mr. Maharaj? The Court of Appeal, in the local Court of Appeal, acknowledged flaws. Reason why the challenge failed before the Court of Appeal was the point system was not cast in stone, simply a basis on which a proper assessment of each criterion can be evaluated. 4 lines down, built-in flexibility should have the effect of taking the sting out of the appellant's complaint. That's what the local court said. What did the board say? What did Lord Dyson say? Paragraph 26. The board agrees with the general reason given by the Court of Appeal for rejecting the irrationality challenge to the point system. So where does that take you?
But if you bear with me, my lord, at paragraph 21, the board agreed that if you're having a point system, it must be reasonably apt for achieving the statutory objective of taking account of Regulation 20 criteria. Our submission is that if you were going to have a point system, you could not treat all the persons who acted in the same category. In other words, if you had an appointment based on the exigencies of the service, and that person was acting in a position in a higher office, you could not treat that person the same way. You should give some consideration to the fact that the statute made a distinction. Well, the statute provided that that these persons are to be appointed based on satisfying the promotion criteria. So our submission is that the point system was not reasonably apt for achieving the statutory objective. And in our written case, we referred to some cases in which the point system was looked at in England. And if a point system substantially excludes the possibility of a statutory requirement being taken into account, then it is lawful. If I refer to the case of the Queen and Lambert, ex parte Ashley, tab 14 at 1633. I won't go through it, I'll just refer it to the board. If a point system is incapable of distinguishing between relevant differences in candidates, then it is illogical and therefore irrational. In the same case, at 1633, that is what it decided. If a point system is incapable of giving priority to matters which ought to be given priority, then it is unlawful. It fails to take relevant matters into account, and I refer to the case of the Queen and Islington, ex parte Riley. The point system applied in this case, we submit, fell foul of those principles and was therefore unlawful. That is, in fact, my first ground of unlawfulness.
Can I just ask you, because I think your complaint actually is that those who haven't satisfied the criteria before they get the acting appointment and those who have are treated the same by the point system.
Yes, my lord. Yes, my lady.
Is there a factual complaint that your group of employees were lost out to those who had not gone, who had been appointed under 1542 provisions, or is it vis-à-vis those who hadn't been acting at all?
Our case is based on the fact that, one, it was a permanent appointment, but alternatively, if it was not a permanent appointment, alternatively, we should have been given preference in consideration.
Yes, but I'm asking about who it is said you were passed over in favour of, and was that people who had been acting but not having gone through the full criteria?
Yes, there were people.
There were those.
Yeah,
Thank you.
Yeah. I'm sorry, my lady.
Sorry, didn't make it clear.
And we put that in the is it Schedule 2?
Thank you.
Those persons were persons who were not appointed to act in the higher office, but they were appointed instead of us.
No, that wasn't the question. The question, it seems to me that your complaint about the point system is not that it doesn't give preference to those who've been acting, but it gives the same preference whether they've gone through the full criteria or they haven't.
Yes.
And I'm asking, as a matter of fact, was there anybody in your group of people who went ahead of your group of employees who was in that category? They'd been acting but not gone through the full criteria. Well, never mind, it doesn't need answering now, but
Yes,
yeah.
I'm trying to get some help from my agent.
Thank you.
My second ground of unlawfulness is that the further alternative point that it was unlawful to apply the point system to the appellants in particular because that did not take into account that they had already been chosen by a different system. We submit that if officers were chosen for acting appointments by the point system and then a reconsideration were to take place for the purpose of promotion using the same system, then the impact of reconsideration might be limited. In those circumstances, Justice of Appeal Barrow expectation would probably hold good. That is to say, in his words, from paragraph 55, which I read earlier, would normally be expected to be appointed to the appellants would normally be expected to be appointed to the substantive post ahead of other aspirants to the office if they have been performing at or above the required standard. We submit that what Justice of Appeal Barrow and the Chief Fire Officer failed to consider was the impact of the change of the system on those expectations. The applicants had been selected to act according to the criteria for promotion under Regulation 158. That gave them the expectation that they would be preferred for promotion. Those expectations were thwarted not through any fault of their own, but the introduction of a new system for assessing the same criteria. The Chief Fire Officer failed to take that into account, and so did the point system. We submit that the point system was incapable of taking into account previous selections under Regulation 158 made using the previous system, which was different but not valid for that reason. Which was different but no less valid for that reason. That is why we submit a second ground of unlawfulness is that it was irrational to apply the point system to the appellants in their circumstances. In answer to the question posed, my lady, our complaint is that the point system does not give preference to officers not chosen to act. The point system does not take specific account of the selection under 154.1 or the requirement that such officers be preferred over other officers. Attached to our appellant's case is a list of officers who were not appointed to act in the higher position, and they were promoted. So I don't know if I have answered the question.
Thank you.
In summary, my submissions, I'm coming to the end. In summary, my submissions on the two issues are as follows. As to the first issue, there is no power to make acting appointments for an indefinite period, terminable by notice. Therefore, the appointments to a high office made until further notice, purporting to be acting appointments, cannot be treated as such. As to the second issue, fire officers chosen for acting appointments by the criteria used for making promotions are to be preferred over other officers not so chosen when promotions come to be made. That is the effect of Regulation 154 and the rest of the scheme. The promotion exercise of 2010, which passed over the applicants for promotion and promoted officers who had not previously been appointed to act, was unlawful because it was based on a point system which was incapable of giving effect to the preference. In respect of relief, if the board is with us, we submit that turning to the question of relief, we submit that the proper relief in relation to the first issue for every appellant appointed to act until further notice is a declaration that they are entitled to be treated as having been permanently appointed to the higher post, that is promoted as of the date of their acting appointments. A subset of these appellants is made up of those whose acting appointments were terminated by notice. They are entitled, we submit, to declarations that such terminations were unlawful and that it should be treated as though they continued to serve in the higher office at all times. The respondent has objected to this relief because it was not expressly sought at first instance. But the argument was run before the judge. The group of appellants, the second group, was specifically identified in the application notice, and I asked the board that I refer to volume 1, page 13, at paragraph 11, Roman numeral 2. And it was argued that the appointments were illegally terminated. See page volume 1, page 25, under the heading Illegal Termination. And see over the next page at paragraph 49, the judge made the finding accordingly at volume 1, page 223, paragraph 4. I'll give the board a reference. I wouldn't really go into it.
Well, there's
The judge,
3 paragraphs on relief
Yes.
at the end of your case.
Yes, madam.
They're very helpfully indicating what you aspire to.
Much obliged, my lord. I should close by saying that if the board finds in the applicant's favor on the first issue, then relief on the second issue will not make a difference in practice. But in relation to the second issue, we submit that the appropriate relief is to make declarations in the alternative that the point system was irrational, unlawful. Alternatively, it was irrational to apply it to the appellants. The appellants were unlawfully passed over the promotion order of the 30th of August 2010, and they're entitled to be treated as having been promoted from that date.
So the question of unlawfulness is not under either of the two issues identified.
Sorry, my lady.
The question of the unlawfulness of the point scheme is not under issue 1 or 2.
Not here.
You have argued that the point scheme is unlawful,
Yes.
but it's not relevant to issue 1 or to issue 2. Is it relied on simply in relation to relief?
It is relevant to issue 2 because...
Well, you say it's unlawful to have applied it to the appellants.
Yeah.
It's irrational to apply the points
Yes, ma'am.
scheme. You're not saying that intrinsically the point scheme is unlawful.
No, I'm not.
No.
I'm not.
Quite.
It's the application of the point.
Quite.
Unless, sorry, my junior, Mr. Strang, Lady Black asks in Jagru were initial appointments temporary. I said no, we should correct that. At paragraph 10, appointments of fixed periods and temporary. Lord Carnwath, distinguished tutor by reference to Section 58 of the Teaching Service Act. Section 9 of the Fire Service Act is in the same terms.
Sorry, I'm not with you. Where do we find section, what was the second section?
Section 58 of the Teaching Service Act
Yes,
is in the same terms of Section 9 of the Fire Service Act.
I see. Okay, thank you very much.
Much obliged.
Thank you very much. Mr. Strang, we'll rise for a few minutes.
Peter, it reminds me of...
The board has decided that we don't need to hear from you, Mr. Knox, but we're very grateful for the very lucid exposition of the issues in the case by the appellants' advisors, and we will take time to consider the judgment that we will deliver. The court is now adjourned.